Could everybody please take your seats? We're going to start. We're going to start here in a moment. What's that? What is this? Good afternoon, or good day, everybody. Not yet afternoon. For those of you who have just shown up, I'm Jim and I'm the Dean of the Law School, and it's my pleasure to welcome you all to the annual Coen Lecture, which is also the keynote lecture presentation of this conference on implementing the United Nations Declaration on the Rights of Indigenous Peoples in the United States. I'd like to just say a little bit about this lecture series. The namesake of the lecture series is John R. Coen, who was a distinguished member of the Colorado Bar. After his passing, his widow Adrienne Coen established in 1955 this lectureship in his memory. The purpose of the lectureship is to bring a prominent and distinguished lawyer, jurist, or scholar of law to deliver an annual lecture to the Colorado law community on a legal subject of public interest and benefit to the profession. This year, we welcome as the 62nd Coen Lecturer, Professor Robert A. Williams, Jr. We are pleased to feature a speaker whose work and scholarship in the fields of American Indian and international law, Indigenous peoples' rights, and critical race and colonial theory uniquely qualifies him to deliver a combined Coen Lecture and today's conference keynote address. Professor Williams is a Regents Professor and the Thomas E. Sullivan Professor of Law at the University of Arizona, James E. Rogers College of Law. He is a highly distinguished legal scholar, teacher, and lawyer who is well known for his work in the areas of federal Indian law and Indigenous peoples' rights. Details about Professor Williams' background and accomplishments are in your program, but let me just provide you a few more highlights. A graduate of Loyola College and Harvard Law School, he is the author of numerous path-breaking articles and books, including his prize-winning book, The American Indian in Western Legal Thought, and his most recent book, Savage Anxieties. His views on issues concerning Native peoples have been featured in major media outlets, including the New York Times, and he has lectured in several countries across the globe. At the University of Arizona, he led the establishment of the law school's Indigenous Peoples Law and Policy Program, one of the premier centers of learning and advocacies on Indigenous issues in the world. While being an outstanding scholar and teacher, Professor Williams is not one to be limited to the halls of academia. He has worked throughout his career to use his knowledge and talents directly for the benefit of Native people, serving as a tribal court judge and litigating in the United States and in international tribunals, as well as counseling Indigenous leaders groups in numerous settings. A note of disclosure, Rob and I have worked together on several projects, including in representing Floyd Hicks before the United States Supreme Court. We won't talk about the outcome of that case, but or other things in which we've done together. But anyway, finally, Professor Williams has for some time been connected to the Colorado law community, serving as a co-author along with Colorado law professors Charles Wilkinson, Kristen Carpenter, and the late David Getchis for their casebook on federal Indian law, which is the premier text of its kind in the field. With his vast experience, which includes lifelong engagement with the issues that are being addressed in today's conference, we're happy to have Professor Williams as our keynote speaker and distinguished Coen Lecture to speak on the question, why do we need a United Nations Declaration on the Rights of Indigenous Peoples? Please join me in welcoming to the podium Professor Robert Williams.
Am I on? Thank you for that introduction. Thank you to the organizers and my colleagues here of this two events, the Coen Lecture. Thank you for that honor. Thank you for the honor of the keynote. And I have many good friends and colleagues in this room, even former students. So I'm honored to be here. And so thank you very much. And thank you, Jim, my lifelong and best friend. So the topic today is a question. It's a question that I've been getting, I don't know, for 20 years. Well, why do we need a United Nations Declaration on the Rights of Indigenous Peoples? You get that from diplomats, you get that from people in Congress, you get that from their staffers, you get that from Indians and indigenous peoples sometimes. Why do we need a United Nations Declaration on the rights of indigenous peoples? Well, I have one good reason. This guy. We will never surrender America's sovereignty to an unelected, unaccountable global bureaucracy. What a tweet. That wasn't a tweet, that was the headline in the speech, right? So that's one reason why we need a UN declaration. Here's another one. The Pope made us do it. Okay. My mentor, who taught many years here at the University of Colorado, our dear friend and colleague, Charles Vine Deloria. When I began my career as a scholar, he had been my hero, like so many young Native scholars of my generations and even generations today. And so I sought him out and I asked him, Vine, where should I begin? What should I do? What should be the agenda for my scholarship? And he said, start with those medieval popes, Williams. It all starts there. And he was right. Because when Columbus sails to the New World thinking he'd discovered Japan, he comes back and having sailed under the Spanish Crown's charter to establish colonies not occupied by any Christian kings or peoples, it conflicted with an earlier papal grant in the 1450s, which had given all of Africa to Portugal. And because the Europeans had no idea where they were going in the world at that time, nobody knew if Africa was where Columbus had landed or if Columbus had landed in India, because everything west after Alexander the Great, after the river Ganges, everything west was called India. You never went there. You know the great story. His army turns back. They wouldn't cross the river Ganges. Everything was wild and desolate and savage peoples and monsters and beasts. And so when Columbus washes up in the Bahamas, Indios, these must be the Indians. And so Columbus goes back and he says, no, I think I've discovered a shorter spice route to Japan, to Sipnago, to the Indies. And it's basically inhabited by savage, infidels, non-Christian peoples who would be ready to worship God, obviously, if we could just send missionaries there. And so the Pope, who luckily just happened to be a Spaniard from the infamous Borgia families, for those of you who like that HBO series, right? You know all about this guy and his kids, the Pope. And listen, I was educated 12 years by Sisters of Charities and the Jesuits, and then 4 years in college on top of that. So this is not my form of revenge. I'm just telling you what I researched. By the authority of Almighty, so he basically follows this Roman imperial precedent of a bull. Okay, the Roman emperor could issue a bull. It was like executive emergency, right? It's an emergency, all right? By the authority of Almighty God conferred upon us in Blessed Peter, of course, he's talking about the Petrine foundation, the legal foundation, the papacy. Thou art Peter, and upon this rock I will build my church. And that was it. That was all you needed for jurisdiction over the entire church, both potential and actual. And now you can tell, how heavily involved lawyers were in the colonial enterprise. They're involved at every step of the way. We give, grant, assign to you and your heirs and successors. Any property professors out there, this warms your heart, right? Isn't this great? This is great stuff. Kings of Castile and Leon, together with all their dominion cities, let's not leave anything out, all right? And all rights, jurisdictions. I didn't make this up. It's in there. You have to translate Latin. That's why I like the Jesuits. All islands and mainlands found and be discovered toward the west and south. So you guys get it all. And later we'll draw a line by which basically Portugal gets Brazil, which is why they speak Portuguese and have better dance music. And then the rest of the world gets Spain. The New World is given to Spain, that treaty line of Tordesillas. But with this one proviso, don't go messing with anybody who's Christian. Don't go messing with their dominions. We're just limiting this incredible colonizing power of empire you have over indigenous savage tribal peoples who seem ready to listen to the word of God. So that's one reason we need a declaration, is because that's where the doctrine of discovery comes from. Columbus, of course, was the first to sail under the doctrine. And I show this map to my students. It's like, you want to be in the, you don't want to be in the green on this map, all right? Because in the green are all the countries that have been under European control. Okay. This doctrine essentially conquered the world. It was the legal doctrine which facilitated the legitimating foundations of colonization and conquest in the New World, in Africa, in Australia, in New Zealand. It's the universal aspect of the European law of nations that applied to all indigenous, tribal, savage, barbarian, backward, unchristian peoples. So that's why we need a UN declaration. We need it because the doctrine was used and utilized as the legal foundation, and not just the foundation, but the actual architecture. The thing to understand about the doctrine that I try to make my federal Indian law students understand, and those I teach indigenous human rights to, is it's not just there in 1823, okay? The foundations had gone back to the Crusades. And the superstructure was during the, quote, discovery era. By the time the founders get a hold of it, the architecture is already there. It's predetermined. You can't vary from it because it's a legal architecture that controls all title in the New World. And every European colonial power claimed rights to the New World and North America and South America under the doctrine of discovery. And that's why you need a UN declaration. John Marshall made us do it, okay? In 1823, Marshall decides the first major case on the rights of Indians to the lands they'd occupied since time immemorial, in which Europeans, since the beginning of the colonial counter, had entered into treaties. And Marshall had actually written a history on the colony of Virginia before he'd become Chief Justice, and had a rich historical knowledge of colonial relations with the Indians dating back to Columbus. He had actually done the research on the discovery of this immense continent. The great nations of Europe were eager to acquire to themselves so much of it as they could respectively acquire. So in other words, this was like the Homestead Acts, right? It was like opening up the homestead, except it was to an entire continent. Its vast extent offered an ample field to the ambition and enterprise of all. And so there's that great, sort of Western profit motive driving European expansion and colonialism. And the character and religion of its inhabitants. They were savages. At one point in Johnson, he says, the Indians were fierce and bloody savages. To incorporate them into our polity was impossible because they were as fierce and high-spirited as they were independent. And Justice Ginsburg cites Johnson v. McIntosh all the time. No, that's not fair, but she has cited it at the beginning of one of her most important opinions on Indian rights. Have you read it? You've gone through the text? afforded an apology for considering them, the Indians, as the people over whom the superior genius of Europe might claim an ascendancy. So they're at the very foundations of Indian law jurisprudence is this racist assumption embedded in there, which asserts a privilege of power and the power of exception. The power to say, no, Indians don't get international status. No, Indian treaties don't count as international documents. No, Indian kids can't go to the schools of their parents' choices. That power of exception, which is the power of racial dictatorship embedded into the very sinews of federal Indian law. The problem with the doctrine was, though, that it just was a hunting license to grab indigenous occupied territories wherever you might find it. They were all in pursuit of the same object. So they needed a principle. The discovery gives title to the government by whose authority and by it was made against all other European governments, which might be consummated by possession, however long that might take, and however much another European power might want to challenge it. Now, again, the point that I make to my students is that up until discovery, European international law was really concerned about indigenous peoples. They had the doctrine of discovery, but magically upon discovery, they drop out. They're no longer subjects of international law. Why? Because Justice Marshall said so. In fact, I do a lot of work in Canada, and the Canadians who feel really proud of their multicultural legal system say, you know, at least we don't have Johnson v. McIntosh. What are you talking about? You guys cite it all the time. I said, oh, no, we don't. So I sent them the list that I just had one of my Canadian students dig up 32 times by their high court. Oh, my. Oh, okay. Had no idea. Had no idea. New Zealand, Australia, Belize, South Africa, all cite Johnson v. McIntosh as leading authority because it's the first case that worked it out. Why bother anymore? This guy had a pretty good rep. It must be solid. Who's going to challenge that? Let's just incorporate it into our domestic law. So those relations, which were to exist between the discoverer and the natives, were to be regulated by themselves. The rights acquired being exclusive. No other power, not the UN, not the OAS, nobody, nada, the Catholic Church, can get in the way of us pushing around our indigenous peoples off the lands and taking the resources that whatever we want, whenever we want, under plenary power, parliamentary sovereignty, you name it. Tihitan made us do it. I like to tell my students in 1955, the year I was born. Okay, so wow, he's ancient, my God. A year after the same court and the same exact composition of justices that had decided Brown v. Board of Education the prior year, 1954. This is what the majority opinion said in a case which basically, hey, you guys have been here 10,000 years. The Russians claimed you by doctrine of discovery. We bought it as part of Seward's folly with, Abraham Lincoln's Secretary of State walking out the door and the Tsar, threw him an offer for like $6 million. He had no authority, but he said, what the heck, $6 million? It became known as Seward's folly. Remember that from grade school, right? None of my students know what I'm talking about when I mention that. But it's a great story because we never resolved the rights of Alaska Natives. We didn't need their land. So we never signed treaties. There was no need to recognize them. Statehood comes along. Still no need. We'll push it aside, have a couple of footnotes, say we're not really deciding this issue. And then, of course, oil is discovered in Alaska. Why? Because you had the Army Corps of Engineers building runways and blasting. They say, hey, this looks like, because where did all the folks who worked in the Army Corps of Engineers come from before World War II? They were working in civil engineering and the oil and gas industry. The U.S. knew the richness of the Alaskan oil fields and purposely didn't want to decide the issue of indigenous rights until the time came. And in the interim, they put up this test case, Tihitan. Let's just take a forest. We'll just take a forest because property law professors, if you can take a forest, you can take minerals, right? So all we need to do is prove you can take the forest without compensating the Alaska Natives, and then it's yours. And Justice Reed says the line of cases adjudicating Indian rights on American soil leads to the conclusion that Indians just sitting on the land, not specifically recognized as ownership by Congress, by treaty, statute, may be extinguished. There There it goes. There goes your Aboriginal title by the government without compensation, because every American schoolboy knows the savage tribes of this continent. This was the same court that decided Brown v. Board of Education. Do you realize how far we have to go? They weren't deprived of their ancestral ranges by force, and I can hear, the William Tell overture in the background, right? Even when the Indians ceded millions of acres by treaty in return for blankets, food, and trinkets, it was not a sale, but the conqueror's will that deprived them of their land. I mean, that is the most blatant form of racial dictatorship that you can imagine within my lifetime. That's why we need a UN declaration. Canada's defense. Again, I pick on Canada. Jim knows our history with Canada, particularly my history. We've worked together on cases. Jim, as UN Special Rapporteur, had a unique relationship with the Canadian State Department. So I'm not picking on Canada, but it's the enemy I know best after the US. This was 1980, okay? How many folks here would admit they were born after 1980, right? Or before 1980? So in a lot of our lifetimes, this is what states were saying. All those treaties, and of course the US thought this was great, and it was the same position that the US held throughout the debates on the Declaration. International, American, and Canadian law, they're not going to say that unless they got permission. Do not recognize treaties with indigenous peoples in North America as international documents confirming the existence of these tribal societies as independent and sovereign states. These treaties are merely considered to be nothing more than contracts. Anybody teach contracts here, right? Strategic breach, no moral turpitude implied, right? Just, no punitive damages in contracts, right? So let's just switch it over into contracts. At the height of the termination era, T. Hittons decided, and you ask any Canadian what's going on in Canadian society with Daddy Trudeau and the white paper and termination there being carried out, and you begin to recognize the political and legal consequences of what Indigenous peoples are starting to realize is that their domestic legal systems have failed them, have totally, completely failed them. Justice Rehnquist made us do it. That's why we need it. Oliphant. White guy comes on the reservation during the Suquamish tribe's most important holy days and celebratory days and beats up a tribal cop. And so they try to prosecute him, and he runs to the Ninth Circuit and says, I'm white. Where do Indians get any business locking up a white guy for beating up a tribal cop on the Indians' reservation? Case goes all the way to Supreme Court. Justice Rehnquist, as any Indian law professor will tell you, does a really interesting right turn in Indian law and says, you know what? There are these implied limitations on Indian tribes. And here's where they come from. Upon incorporation, and by that he means conquest, surrender, capitulation, whatever. Play the William Tell overture again. Into the territory, the US, the Indian tribes, so they just got absorbed, okay? The Indian tribes come under the territorial sovereignty of the U.S., their exercise of separate powers constrained so as not to conflict with the interest of this overriding sovereignty. That makes such perfect logical sense. We conquered you. Why would we let you lock us up? You think, do we really expect a good deal from a tribal court when we come before you having beat up your women or your children or abused other members of your tribe? You think we'd want to submit ourselves to your jurisdiction? That's not why we took the continent from you, after all. We're the overriding sovereignty. You can't do a single thing contrary to our interest. And who does he cite? Remember, Justice Marshall made us do it. Johnson v. McIntosh, alive and well. One of my books is Like a Loaded Weapon. It comes from Justice Jackson's famous dissent in Karamazov. He had been a poker buddy of Roosevelt as part of the kitchen cabinet. Roosevelt thought he was a sure vote for the Japanese internment policy. He wrote one of the most incredible dissents. And when my students say, well, I always say, who's your hero? And I don't have a hero, Bill Gates, whatever. What? No, go read Justice Jackson, where he says, this is horrible what we're doing, upholding the constitutionality of locking up our own citizens in internment camps. But what's even worse is we're embedding it in precedent. where it can be perpetuated again and again like a loaded weapon by any hand that wants to take it up. Johnson v. McIntosh, the loaded weapon of Indian law. That's why we need a UN declaration. This is why we need a UN declaration. This was the aftermath, and I'm not just asserting that. Amnesty International and numerous other international investigatory bodies, NGOs confirmed the linkage between the state of utter lawlessness and chaos created by Oliphant and its reliance on the doctrine of discovery in Johnson, and the epidemic of sexual assault and brutality by non-Indians perpetuated against Indian women and children on the reservation. And with that coalition of human rights groups and women's groups and Indian groups, we know how hard Indian people fought for those amendments to tribal VAWA and how hard it is for those tribes to implement those without the proper resources and training that they need. And I know both of our schools and a number of law schools in the West are heavily involved in that work. And I salute that work. It's incredibly important. But it's why we need a UN declaration. The United Nations made us do it. How come Indians were left out of the self-determination right that all peoples were guaranteed in Article 1? By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. I remember I was with Jim. He actually sort of showed me the ropes at the ILO and working group when ILO 169 was being debated. And Indigenous peoples insisted that we use the S. We had to have the S. And the ILO and the state said, no, you can't have the S because that would imply you have rights under self-determination. And I remember Daley stood up and said, we're not a population. We're not a people. You're talking about, seals and other types of population. We're peoples. And so they gave us a footnote or something, I think, right? Or, said, well, we're not going to say it necessarily means you're peoples for purposes of self-determination, but we'll let it evolve. And it has evolved, in fact, to now where the UN does accept. But when the UN started out, and they started out to decolonize under Article 73, Europe was trashed. The last thing they needed was problems in Algeria and India. They wanted to get out of the colonization business quick and get all their capital out as quickly as they could. And so they set up way in the back end of the UN Charter, Article 73. Just came out in Chongas, right? Really important case. People don't know how important these UN procedures are, but it has the ability to upset the entire balance of power in the Pacific. On Article 73. Coming out of World War II, you would list your various territories and independent colonies for self-determination through some sort of plebiscite. And everybody understood the deal was that it only applied to Africa and Asia, because Indigenous peoples were saying in North America, in Australia, in South America, what about us? Why don't we have the right to self-determination? Why can't we decolonize? And that was a real problem, so they turned it over to a bunch of experts, okay? And out of this comes the Belgium thesis, which says self-determination applies to everybody. Why? Because Belgium was trying to hold up the whole process. And so the Western powers, including Russia, which had indigenous peoples within the Arctic Circle, we're going to get our legal scholars to really take a close look at it. And they came up with this brilliant thesis. Decolonization only applies to any colony separated by salt water. And well, what's the reason for that? Because decolonization just applies to any colony separated by salt water. So you guys in North America, Australia, New Zealand, if you've been basically overrun by settler states, this is where you go. You go to the Kumbaya article. It's an important article, but basically you're saying, look, you're just a minority group. Don't worry, you're protected all the way down in Article 1, 2, 3, 4. Oh, Article 27, there you are, okay? You get to sing and dance and eat food and have St. Patrick's Day. Just don't worry about it. You'll be protected. But the problem was, this was the birth of international energy and natural resource and mineral resource and timber extraction, the Western economies and the globalizing economies in Asia and Eastern Europe and the liberation of the Soviet Union. states and Russia itself just competing and consuming and burning as much natural resources that they possibly can. Pink dots, that's a resource. And wherever you see the hatches, that's where indigenous peoples live. And they were getting slaughtered. And so their domestic legal systems were totally failing them. And I always, whenever again, why do we need the UN? Why do we need the UN Declaration? You guys are ineffective. Who cares about the Human Rights Commission? Who cares about the OAS? And well, you don't understand. You only turn to the international legal system when you've exhausted your domestic remedies and been totally screwed over by your home government. It's when you guys have failed that we have no other choice, as a last chance desperation, just to shout and say, hey, before we're gone and extinguished, please try and pay attention to do something for the very weak, ineffective mechanisms you have, but they're better than nothing, and sometimes they actually do work, or at least slow it to ameliorate it, so we can get a chance to breathe and get free, prior, and informed consent and all the other rights in the UN Declaration recognized. That's why we need a UN Declaration, and that was the argument that indigenous peoples, and I was privileged to be there during some of those years, seeing indigenous peoples participate in the working group, in the Inter-American human rights system, getting inclusions, specific inclusions in on important conventions and UN documents. And you know what? They proved that the power of stories. For those of you who were there in Geneva and saw you get what Madame Dye would give you 5 minutes, and she would shut you down, and you couldn't make a complaint against the state, right? You had to put in this sort of, I'm going to give you information about my village getting slaughtered, but I can't really say anything bad about the state doing it. And so they needed lawyers' help and experts' help, and we helped facilitate that role. But to have the power of those stories, and even these UN experts, independent experts, didn't know anything really about indigenous peoples. One of the greatest champions from Cuba, they had gotten rid of all their indigenous peoples centuries ago. But they got it, they listened. And I think really, if you look at the roots of the No DAPL movement and all the anti-corporatist movements of indigenous peoples against massive energy development, that's where it begins. In that period of international advocacy and working those halls in Geneva and the UN, urging those states and telling those experts why we need a UN declaration. And eventually they get it. Oh, I see, you're saying Article 27 is minority rights, but you're different from every other minority because your survival is somehow tied into your land, your resources, is that what yes. Oh, well, in that case, we probably need a little bit bigger framework than Article 27, particularly when you give us this compelling evidence and these stories of how this system is failing you. And so you begin to see the language of the system evolve, and it's only one reason it's doing so. Because of the active participation of indigenous peoples who believed in that system is giving them more of a voice and more power and influence than they ever received back home in the halls of their own governments. I hope you picked up the little book, the UN booklet I saw out there. Whenever I give workshops, I give that little booklet out to all the tribal leaders, states, governments that I work with. I cite, Senator Burr from West Virginia used to carry around the Constitution in his pocket and really befuddle his colleagues. And again, we train, and Jim has worked with us when we was at the U of A, when we train our indigenous leaders and lawyers, cite the Declaration, and will befuddle the hell out of those white guys. They have no idea. Oh, let me call back, okay, to Ottawa. Let me call back to DC. Oh, what do we do now? Oh my gosh. Now you've got investors, and now you have corporate stockholders and risk assessment. You've got people listening to you for the first time ever because you figured out how to use the internet effectively, and your power in Washington, and your economic power, and your moral power, and your spiritual power. And the 21st century sees us organizing around all those powers around the UN Declaration. Nobody was citing federal Indian law up in those camps in the Dakotas. You would go there, and my students would take pictures for me of articles of the Declaration. And the various provisions, such as in the preamble, which basically says don't go citing the doctrine of discovery anymore as a legal basis for any rights. because we rejected anything that deals with national origin, racial, religious, ethnic, or cultural differences are racist. They use the R word. You think that was easy? To get all those states to vote for the R word in the preamble? And yes, they read it very carefully, but that's what it is. A lot of folks forget the institutional mechanism through which the Declaration emerged. It emerged out of the minority rights and the covenants on racial discrimination and the Cobo Report, because that's how it was originally seen, again, through the stories of indigenous peoples and advocacy. That international legal system, we get it, we know what you're saying, and we agree that you have the right to self-determination. If there was any doubt about that, your peoples with an S. We agree that your land is integrated with who you are, the three core values of human rights: cultural integrity, cultural identity, cultural survival. After World War II and the Holocaust, the thing I tell my students is the great thing about the international human rights system, for all its faults, it begins with the assumption, and nobody will argue, that the Holocaust was a real bad thing. And we should do everything possible in our human powers to make sure it never happened again. And the mechanism we're going to choose is international human rights. And we're going to do everything we can to get domestic governments to obey those promises and commitments they make in that process and in those international human rights treaties, such as rights to land, resources, waters, rights to a fair process, the right to own, use traditional territories. It doesn't matter that the state has drawn a boundary around it. If your traditional lands outside of that boundary are vital, or if your traditional lands have never been titled by the state, titulo, right? In Spain, titulo. That's all they say. They thought all you had to say was titulo and it was over. Where's your title? Get out of here, you mongrels. Get around, you lower caste. Who do you think you are? Challenging our authority. We need it because it guarantees the human right of, hey, ask me before you take steps to destroy me, okay? Before you pollute my water, foul my air, take my children out of my home, relocate us from where we've been for 1,000 years. Would you sit down at the table, please, and talk about it in open, transparent manner? Is that too much to ask? Apparently. Is it too much to ask that where we can make a really compelling case that what you're going to do is a really good chance of destroying us? Please get our free, prior, and informed consent. We're not saying we're totally opposed. Maybe we can work out benefit sharing. Maybe we can tell you areas to avoid. Maybe you might want to listen to us. We're working right now with the Eastern tribes, non-recognized tribes. My tribe, the Lumbee, I'm very proud to be working with them, and the other Eastern tribes in which FERC refused to consult with the Eastern tribes on the Atlantic Coast Pipeline because they weren't federally recognized. So therefore, we didn't have to hear anything. You could just submit your evidence along with everybody else in the FERC process. My God, I asked one of my students, what is the FERC process? I said, Professor Williams, you want me to bring it in? Yeah. He says, well, I'm down at the car. You want me to carry it up? You want some help? Okay. It's like that far. It's that long. And so getting our free, prior, informed consent, particularly where states say they don't recognize it, at least give us another way of talking about it, at least going out to shareholders, at least going out to banks. One of the things that I'm most impressed by, why do we need a UN declaration? Because banks and lenders and investor syndicates and risk assessors and reputational risk assessors are now paying attention. The work done here by Colorado on the Dakota pipeline and the impacts, I hope everybody looks at that and the financial impacts upon that. It's incredibly important work. And indigenous rights advocates and their supporters need to use that work and just forget the BIA. Go right to where the money is. Like I said, why do we need the UN Declaration? Amnesty International wrote to the governor, citing important human rights concerns that appear intended to intimidate peaceful protesters, a pattern of cases. I know our clinics have been very much involved in working with the kids up there and those who are facing prosecution and pursuing remedies in international human rights forums and anywhere we can on these issues. These are the most important issues of this generation, and they inspire this generation of students The millennials, this is what they want. This is what they want to do. How do we harness their power within our institutions? And Jim, my good friend, the dean, if there are alumni here, write a check, okay? He'll tell you how to spend it, okay? This is a great place to do this work and have a global impact. So is the U of A. We can have a co-arrangement, okay? I've got my alumni, you get yours, right? Okay, do great things with the Declaration as the mission and centerpiece of everything you do. When I give workshops with tribes, use the Declaration of everything you do. How you work with your own people, how you work with other governments, how you work and respect other peoples that you may disagree with. Because otherwise, this is what happens. I was in Birmingham giving a talk at the Civil Rights Center there. If you've ever been there, besides Son of the South, the food is phenomenal, okay? But the legacy, it's where Martin Luther King started his great freedom walk. And when you go into the museum, the folks there who are showing you around, you can't work there unless you were with him on that freedom march. And so the richness of the history. And you walk out, and directly across from this park is the 16th Street Baptist Church, where those girls were killed. And you see the 4 ceramic flowers. And you see this, and you realize this is why we need a UN declaration. Nothing has changed. It's getting worse. Your every law enforcement officer who uses tear gas is trained never, ever spray somebody in the face when they're in water, because they may not be able to breathe and they'll drown. And you've got tear gas equipment off, you may not be able to get it off quick enough to resuscitate that person. And we will be sued big time. These guys, classic Sun Tzu, right? They have the upper hand, they have superior weaponry. These kids are just up there holding up signs, and this is what they do. This is why we need a UN declaration. Again, walking the streets of Birmingham, seeing those pictures, and then comparing them and contrasting. Okay. Finally, why do we need a UN declaration? Because of these types of abuses which were occurring globally and reported to Jim's successor, UN Special Rapporteur Victoria Tali-Corpuz, she made a report to the Human Rights Council on the suppression of indigenous human rights defenders by state governments and paramilitary forces and private police. She said there's been a distinct surge of instances of physical violence, a global crisis, and she correlates it clearly between indigenous peoples and the private commercial profit-driven business initiatives aimed at extracting value of land. Over 70 written submissions, and this is what she found. Indigenous peoples who seek to defend their rights are the targets of extreme violence. 312 human rights defenders killed in 27 countries. 67% were engaged in the defense of environmental indigenous rights. Nearly all occurred in the context of mass projects. Most of these financed by American, Canadian, North American businesses that are receptive to listening and being shamed in front of their shareholders in the world because it hurts their reputation by citing the UN Declaration. No, and I've talked to enough folks and we work with some of them, and they're actually, I say, overall, it's the major corporations that are much more responsive to these issues than a lot of the state governments, because it's their bottom line. It's now become part of business risk. I don't necessarily care why. I don't want to preach to the choir, but I think we can sharpen our arguments and really be effective advocates. Alerted to hundreds of cases. These attacks are an attempt to silence our voices. Remember what I said about the power of our stories. Now, in fact, we know Vicky, and I'm proud we taught Vicky's daughter and know, just an incredibly wonderful, humane person who walks into a room and sort of elevates, the feeling of love and connection and belief in our ability to come together Just an amazing human being to be in that position. And this is what she encountered a few months ago. A United Nations Special Rapporteur who has won more than 600 people, the Philippine government. We know that guy is, really stable, right? Once Claire des Terres said she feared for her own safety and that of other activists on the list. The Philippine Justice Ministry, this would be like our Justice Department, filed a petition seeking declaration of more than 600 alleged communist guerrillas as terrorists, according to the document. There she is, right? This type of person goes right through the security lines at the airport, okay? This is not a terrorist. And yet she did not feel safe to go back home because of the seriousness of those threats. Here's the final reason. We need a UN Declaration on the Rights of Indigenous Peoples. It's the vision of the Gus Van Ta. People who've read my work for a long time, oh no, he's going to do the Gus Van Ta card again. Have you changed the slide at least, Rob? Did you get up to a more modern font? Okay. In my classes, yes, I plead guilty. I've been writing this one for a long time, but I've talked to a number of Haudenosaunee and elders and belt keepers about it and researching this book. And so I've been given permission to say some things and some interpretations. Many of these themselves are major Native scholars, are things I can say about the two-row wampum. It was used widely, and I wrote a book, another plug, Linking Arms Together, Loaded Weapons, American Indian Savage. I got them all in. Very good. Thank you. Okay. So, in the beginning, Indian treaty traditions, were the 13 wampum belts of the Hiawatha Peace Ceremony, or, white buffalo calf woman's exchange of the peace pipe between the Arakawa and the Sioux, or the Lakota, or the Beaver Chain Covenant of the Upper Midwest. And it was basically, come in and join us. We're multiculti, okay? We think you become stronger as a people when you bring people in who bring valuable resources, perspectives, new ways of doing things. Wow, what a radical vision. Okay, that's why Benjamin Franklin at the 1754 Albany Convention says, if these savages can come up with that idea that by confederating as 5 strong peoples, you have 5 arrows tied together, much harder to break, then how come us 13 civilized white man colonies can't do that as well? The Iroquois, Haudenosaunee origins of the U.S. Constitution. Well, that vision starts to, sort of fade away as Indians figure out, these white guys, they're really not getting it. So let's revise our treaty belt, sort of template. And what you find is the preponderance in Dutch and in French and even in U.S. treaty relations where some form of the two-row wampum appears. And it's to get back to this vision of the two-row wampum that I say we need the UN Declaration more than ever. Because anyone who works in Indian country, anyone who has the privilege of teaching our native youth and their enthusiasm, and our non-native youth, who understand that alliance with indigenous peoples is a matter of their survival, not just indigenous survival, that we're all in this together, and that we know native knowledge, native wisdom can give us an answer on how to address some of these problems of multicultural unity. And so when the Gus Van Ta was presented, this is what they were told. Because the white man always wanted to be father and son. And the oral tradition was, we will not be like father and son. But if you accept this treaty belt, the two-row wampum, where white is the color of peace, and blue can be the color of war, but it can also be the color of blood and affinity and relationship. And it can also be the color of water as a border. And so they explain what this meant. These 2 rows symbolize 2 vessels. And in some of the belts, you actually see little brown beads on the water. And the oral tradition is one of those beads represent the Iroquois birch bark canoe, and the brown for the English represents the man of war. But notice, they're traveling down the same river, but each for the original peoples have their own laws, customs. And you Europeans, you have your own. We will each travel the river together, but each in their own boat. And neither of us will try to steer the other's vessel. Thank you very much. Take questions now.
Thanks. Thank you, Rob, for that terrific and inspiring talk, and very apt for this conference and for our Coen Lecture. Rob has agreed to take some questions. We have about just over about 7-8 minutes. So.
Yes.
So my name's Bree. I'm a graduate student down at the University of Colorado down in Denver. And so during your talk, you said, this is where it begins in regards to indigenous movements against extractive and energy corporations that are exploiting the land and also bringing more violences to the indigenous peoples living near those extractive zones. How do you reckon with genocidal Newmont Mining, who, by the way, is recently engaged in a joint venture with Barrick Gold to mine Western Shoshone land, being a main partner of this very conference?
They're a partner here?
Yes.
Okay, listen. When I was, even maybe 15 years ago, I'd go there on the other side of the microphone and I'd say, yeah, what about that, Jim? Okay? But, you know, I'm older now. I've focused on building effective programs within these institutions. You know, you plant your flag where you need to plant your flag. And where you think you can do the most good and achieve the most education. You know, trust but verify, all right? I will cite, here's my answer to you. I will cite my dear, beloved mentor and teacher, Derek Bell. Derek was the first African-American professor at Harvard Law School. I idolized him. And Derek talked about the interest convergence dilemma. Derek would tell you, just get one good idea, you know, if that's all, you know, Einstein had E equals MC2, Arrow had Arrow's theorem, you know, this was Derek's great idea, interest convergence. And critical race theory, Jim mentioned my work in that, and it's, even when my students come back, I said, where's your interest convergence? Where was the interest convergence in Johnson v. McIntosh? Where was the interest convergence in Cherokee? And you ask, and I said, my student, well, what is interest convergence? Well, Derek said it means that white folks won't do nothing for colored folks unless it's in their interest. Duh, the majority won't do anything for the minority unless it's in their interest. That's the principle of democratic theory. You hope you have an effective court system that has effective rights to strain in these damn corporations, which by and large are the enemy. But if you can get one on side to sit down here and listen to us talk about it, and I hope they contribute to the dialogue. Again, going back to Birmingham, you know, I'm 1955, so you can add it up. You know, I'm a Lumbee kid watching MLK. I saw it live. I saw that speech. And if you're from Pembroke, North Carolina, you know what that means. And so, you know, I cite that to give you hope that, as Dr. King said, if you talk to a person long enough, you'll get down to the heart and side of them. So. Oh, come on, I'm not that scary. Yes, please.
Dagote, Sky Roosevelt Morris, Sanse. My name is Sky Roosevelt Morris. I come from the White Mountain Apache Nation and the Shawnee Nation. I'm a member of the American Indian Movement of Colorado. And I'm really honored to see you here, Professor Williams. You're a really big hero of mine. I've read pretty much every one of your books. And so it's just a real honor to ask you a question. But I was kind of unsatisfied with the answer that you just gave. And in talking about the Declaration, one article that you overlooked was Article 46. And so when we talk about international relations and we talk about indigenous peoples, we talk about Standing Rock, what people at Standing Rock were standing on was being members of the Ochete Shakoi, the Great Sioux Nation, not tribes, not domestic dependents, but nations. And under Article 46 of the UNDRIP, that aspiration gets greatly diminished because we can never call into question the territorial integrity of the United States government. And so this conversation about FPIC giving back the Black Hills to the Lakota people, it's a fallacy under Article 46 of the Declaration on the Rights of Indigenous Peoples. And I think, you know, to your earlier point, I think that Mary and Carrie Dan would have something very different to say about supporting getting funds, being supported by Newmont Mining, because I know that both you and Jim worked on that case that actually got a really good international standing that supersedes the Declaration. And so to act as if there aren't already mechanisms in place outside of the Declaration for Indigenous Peoples and to not welcome that sort of conversation, I think is problematic to Native peoples in this room. And so I would just urge you to think deeply about those things, about if you're going to advocate for the Declaration, then advocate for it in its entirety, including its imperfections. Article 46 being the most important. You can't talk about any of the other articles without addressing Article 46. Thank you very much.
Okay. Do you want to respond? Sometimes people don't want to respond. I'd be happy, but if I don't necessarily want to respond because I didn't get the last word. But again, if I was a little bit younger, I'd probably be on that side. That's where I was. Okay, there are people in this room who know people outside of this room who thought I was crazy, all right, for saying stuff like that and writing stuff like that and still believing it. But there are so many respected elders in this room who've been part of this battle, who know, Charles, where you guys started from, you and Ralph, right, and David, and the legacy of NARF and some of the old timers here. I'm 64, I turned Monday, okay? And it makes you think about things because I love that old Beatles song. I thought it was such a joke, and that's what I get sung at my birthday, when I'm 64. Well, I am, damn. But there you go, right? There's a lot of wisdom. There was a lot of mistakes. There was a ton of compromises made to get to where we're at. We all wanted a perfect world, and we still want a perfect world. Why did they? This is implementation. Okay, a lot of the heavy lifting has been done, guys. A lot of the heavy lifting, thank God. Go out there and change the world. Kick butt. It's yours. We're not going to be around. This isn't a morning war. I'm not going to come back and haunt you because you cut something from my casebook or don't read my books anymore in your Indian studies curriculum, okay? So go for it. There's nothing you said that I couldn't make a great argument for and have made those arguments. Unfortunately, you get into certain roles at certain points in your life within your community and with your people where survival and perpetuation and creating for the next 7 generations, you take that responsibility very seriously. And I love you guys, and you can kick my butt anytime. It is an honor to have you make me rethink and talk about some of the things that are most important to me. Hands raised.
Great. Thanks, Rob, for taking those provocative questions, and for those who've spoken up, you're very welcome here. Unfortunately, we're out of time. You're all invited to the cafe just upstairs for lunch and the fireside chat with Charles Wilkinson and Rebecca Sosi. There might not be enough room in there. There's an overflow room which is the Kerrigan courtroom just next door. So you can watch by a video if there's not enough room upstairs. So anyway, thank you all for coming. And thanks again for Ralph.